Hi, Sarah Jacobs here. Today we're talking about all things divorce, and specifically the types of things that you, as a litigant, will likely encounter during the divorce process. I'm going to provide you a list, and I know that you might see all of the things on my list, some of the things on my list, or quite possibly more than the number of things on my list. But we're hoping to touch upon a few common themes that most litigants encounter during the court process and make it a little bit easier to understand. We know that it's one thing to read all about the divorce process on a website and another thing to be experiencing it. We also know that we, as attorneys, sometimes speak a foreign language, and here's an opportunity for me to break that down into ways that you can understand. Let's start with pleadings. Pleadings are the words that we lawyers use to describe documents that are actually filed with the court. The documents to start your divorce, answer things about your divorce, or tell the court things that the court needs to know to make decisions are all different types of pleadings. This can include a complaint for divorce, an answer, a counterclaim, a notice of appearance, a final judgment of divorce. These are all documents that you're likely going to encounter during the process, but now you know that pleadings means filings with the court. Usually, a complaint for divorce is the document that starts the whole process, but it's commonly misconceived that that has to be the first document that's filed with the court. Sometimes you don't even file a complaint until after you've negotiated the entire settlement and signed a written settlement agreement. It's important to be clear about when this works for you in your process. So speaking with an experienced family law attorney really matters. The next thing I am sure that you will encounter in your divorce is documentation, documentation, documentation. There is no shortage of paper exchanged between attorneys and the litigants and attorneys and the court in a divorce case. The type of documentation can range wildly, but what's really important, and my hot tip to you, is you need a place to store it all and keep track of it. If it's electronic, find some kind of storage system on your computer or other electronic device and make sure you can access everything. If it's actual paper, which is more uncommon these days, but still happens, large storage bins that are labeled that you can easily file through and find a document is your best case scenario. The first type of commonly exchanged documentation is financial documentation. The cornerstone of this in family law is the case information statement. This is one document that talks about all of your family's income, expenses, assets, liabilities, and other pertinent financial questions. But you'll probably also need to produce and exchange tax returns, bank statements, brokerage statements, retirement account statements, and a host of other financial documentation. Getting this together before you start your divorce process helps keep you organized while it's going on. And trust me, it also helps your attorneys. The next type of document exchanges is more along the lines of proofs. Proofs are things like photographs, email exchanges, text message exchanges, audio or video recordings, or anything that you have that helps either give your attorney information, documents conversations that you had with you and your ex-spouse to be, or proves something in your case of a claim that you're making that the court really needs to understand. Another type of documentation that is commonly used are known as records. This could be medical records, education records, a driving abstract, or anything from a third party that documents an issue in your case or helps prove a claim that you're making. We've talked a lot about the stuff that you're going to encounter in the divorce process. And now I want to focus a little bit more about the experiences you're going to have during the divorce process. One of the most common experiences you're going to come across is that of mediation. If you're filing a divorce and you have children, you're absolutely going to have custody and parenting time mediation. This is 2 hours free in the courthouse with a trained mediator to help you try to come to resolutions between you and your co-parent on all things related to kids, the schedule, the holiday sharing, how you're going to do pick up and drop off. This is where the court gives you an opportunity to work towards resolution at the early stages of your divorce process. Later on in your divorce process, after you've gone to the early settlement panel, and I'm going to talk to you about that in a minute, you're going to go to what's known as economic mediation. It's exactly what it sounds like. It's mediation with a trained third party to help you try to resolve all of the outstanding financial issues in your divorce. It's to try to settle any alimony, equitable distribution, child support issues, or any outstanding financial concerns you haven't yet been able to resolve. This mediation is solely focused on the financials because hopefully you've already resolved the custody at your custody and parenting time mediation. One of the common misnomers that clients come to our firm with is, if I'm litigating, how can I also be mediating at the same time? What's really cool is that private mediation can take place before you even step foot in the courthouse or as a complement to it. Lots of families who are already engaged in the court system do also get a private mediator, and that mediator can talk about all things, kids, financials, or anything else that's important to you and your family. The key here is that mediation can be customized and can lower the financial outlay of the parties and your stress. This one may seem like a given, but the last experience you're going to encounter in the family divorce process is court appearances. One of the things that clients tell me, though, is how surprised they are at the different number of appearances and the different layers of court appearances. Most of the time, you're going to encounter at least one case management conference. Sometimes this requires your attendance, and sometimes it's attorneys only, but it's where the judge finds an opportunity to really manage the case by creating deadlines and letting you know when certain things you have to do can be accomplished, such as appraisals, valuations, exchanges of all that documentation we talked about, and to make sure that your case stays on track from a timing perspective. The next thing that you'll probably encounter is an early settlement panel, which is what I mentioned before. This is where other family lawyers who aren't involved in your case volunteer their time to read position statements put together by you and your attorneys on the outstanding issues in your matter. They give you recommendations based upon their years of experience and their interactions with the judge in your matter to try to help you settle your case. This gives you an opportunity to hear from third parties not invested in your matter from a bird's eye view to see if you can come to a conclusion. The last thing that you'll probably encounter in your case, if early settlement panel is unsuccessful, is what's known as an intensive settlement conference. This is usually an all-day affair in person at the courthouse where you and both of your attorneys show up and you spend the entire day talking settlement. You have the opportunity to speak about the issues not only to each other, but to your judge or another family law judge in the courthouse and get feedback on, without knowing all of the details, the way that the court might rule. This helps guide you towards a resolution and saves you the unnecessary cost and expense of a trial. While every family and every case is different, and your case might see some of the things we talked about or more things like domestic violence hearings, child support enforcements, appeals and motions, these are common threads throughout most divorces and something that you'll probably encounter. Still have questions? We've got answers and cheat sheets and handouts and other things to share. We're happy to talk to you. We look forward to speaking with you.